A Senate hearing meant to review Justice Department oversight just exploded on live television. What began as calm procedure turned into a political cross-examination, and this time, the person who built a career dodging questions finally got cornered.
Let's suppose that I'm appointed special counsel at the Department of Justice, and I go to the telecommunication companies, the phone companies. Let's single out AT&T, and I say, look, I know you're busy, but I want to see a copy of the phone records of a sitting United States senator. They're not going to just give them to me, are they?
No, Senator, of course not.
In fact, they're probably going to ask me what planet I just parachuted in from, aren't they?
Yes, Senator.
They're going to tell me to come back with a subpoena, aren't they?
Yes, Senator.
Okay. What do I have to show in that subpoena to get those phone records of a sitting? Did I mention it was a sitting United States senator? I can't remember. What do I have to show to get the phone records of a sitting United States senator?
Yes, Senator, there were actually 8 sitting United States senators.
Yeah, I heard that.
And you would have to have cause.
I'm sorry, what do I have to show?
You would have to have cause to get the
Good
subpoena.
cause or probable cause?
Probable cause.
Okay. Probable cause, or if it's a subpoena deuces tecum, good cause, to show what?
You would need good cause for a subpoena ducis tecum, and what you would have to show is that you believed a crime had been committed, or there was a possibility of a crime, or that could lead to other crimes. We frequently, in criminal enterprises, subpoena cell phones.
By the sitting United States senator?
Senator, they would have to have believed you were part of a criminal conspiracy, is my understanding.
Would a judge have to sign off on it? On the subpoena?
Yes, Senator. Well, for a subpoena ducis tecum, Jack Smith probably took it straight to the judge.
Now, the phone companies, particularly their general counsel, if they're worried about civil liability, even with a subpoena to get the phone records of a sitting United States senator. Did I mention it was a sitting United States senator?
Yes, Senator.
The general counsel for that phone company, let's say AT&T, they have the right to seek to quash that subpoena, don't they?
Phone companies frequently do that.
Yeah. And a smart general counsel for that phone company is going to call the sitting United States senator and say, would you like to weigh in on this? Would you like me to quash the subpoena? We're talking about invading someone's privacy here by a sitting United States senator. Could the general counsel for the phone company do that?
Well, Senator, if they believe that a crime could have been committed, they could not tip off the person who committed the crime. Again, I can't comment on details of this particular case.
I'm just asking you theoretically.
I've never seen you commit a crime, Senator Kennedy.
But let's suppose, okay, they didn't want to tip off the sitting United States senator. But the phone company and the general counsel for the phone company, or companies, if there were more than one involved, could say, you know, this is serious as an aneurysm. This is serious as 4 heart attacks and a stroke. This is a sitting United States senator. So general counsel would likely advise the CEO, well, you need to file a motion to quash. The telephone companies could have contested those subpoenas, could they not?
Hypothetically, yes. I can't talk about the facts of this particular case.
We're talking hypothetical.
Senator, subpoenas are issued all the time through phone companies working with the general counsel.
But they can file a motion to quash.
They could, yes.
Yeah.
In any case.
And if they should have filed a motion to quash, and a reasonable person would have filed a motion to quash, because this is a sitting United States senator, and they didn't file a motion to quash, they would incur civil liability, wouldn't they?
Senator, typically phone companies follow a subpoena from a United States
No, they
attorney.
do, but they don't have to.
They could challenge it, Senator.
Yeah. And if they don't challenge it, they better have a damn good reason. Right? Right?
Senator, I can't talk about the facts of this particular
This is just a
case.
hypothetical.
In general, hypothetically, Senator, maybe they didn't recognize any of the names of the 8 sitting United States senators.
Hypothetically.
That was a joke.
Or maybe they should have gone to Amazon and buy some testicles online. Instead of just saying, sure, I'll just show you the phone records of a sitting United States senator on the basis of an administrative subpoena. Now, do you have copies of the subpoena applications for
Yes,
these
Senator,
8?
Senator, I can't discuss anything regarding
You
this
can't
case
even
with
tell me if you have copies?
I can't discuss any of this.
All right,
with
when are
I'm
you
sorry.
going to, General, when are you going to be able to discuss it?
I can't discuss whether there is or is not a pending investigation,
I understand,
Senator.
but
This was
let's
just
assume
brought to light
if
by
there is a
Director
pending
Patel.
investigation, I don't want this to get swept under the rug, okay? Because I think you're going to get pushback from all quarters. I think the telecommunication companies are going to be all over you like a bad rash because they've got liability here for just turning over these records when they knew what was going on. I think some FBI agents may have some liability here. I think a special counsel might have some liability here. If I were your special counsel and you had appointed me and I wanted to get the records of a sitting United States senator, is that something you would expect me to tell you as Attorney General of the United States?
They better have.
Yeah.
And
Do we know in this instance of the 8 sitting United States senators if they told Attorney General Garland?
Senator, I just learned about this very recently, as did Director Patel, and we cannot discuss the details. I don't know many of the details.
Well, maybe we ought to get Attorney General Garland here. Do you know if the special counsel told FBI Director Wray? Is that something? Let me put it another way. If I were your special counsel and you were the director of the FBI and I'm trying to get the phone records of a sitting United States senator, did I mention it was a sitting United States senator? Is that something that you would expect me to tell you as director of the FBI?
In general, I would believe the FBI would help execute the subpoenas
Yeah.
to the businesses.
Okay, I want to switch to another subject.
Kennedy's questioning wasn't flashy. It was surgical. He began by framing a constitutional issue every viewer could grasp. If investigators really seized senators' phone records, who signed off, and on what legal grounds? Behind the plain phrasing sat a serious charge that federal investigators might have sidestepped the judicial checks meant to protect everyone's privacy. To get those records legally, Kennedy explained, the government must show cause and obtain a judge's subpoena. The process is designed to slow things down, deliberately, so emotion and politics never override evidence. Skip those steps and it isn't efficiency, it's overreach. Bondi's response was textbook containment. She cited pending investigations, invoked confidentiality, and redirected questions to the FBI. Each phrase was technically accurate but emotionally empty, the kind of bureaucratic language that tells the public nothing and signals that something is being protected. Kennedy refused to let it slide. He translated the law back into human terms. If a telecom handed over your records without a judge's order, you'd be furious. So why should a senator, or anyone, accept that? That line landed because it wasn't partisan, it was personal. Viewers watching the exchange could see the tension shift. Bondi maintained composure. But her pauses grew longer. She leaned on loyal-sounding phrases. Those matters are before the court. I can't discuss specifics. Kennedy countered with specifics, names, dates, procedural steps. Each time she deflected, he restated the question even plainer. By the third round, it was clear. One side was answering. The other was explaining why it couldn't. Reports surrounding the hearing later suggested that a special counsel team, during the so-called Arctic frost probe, accessed communications tied to multiple senators. Whether it was 8 or 9 names didn't matter. The constitutional question did. Did investigators follow the law, or did someone cut corners in the name of urgency? Bondi's unwillingness to say who authorized what transformed a policy debate into a trust crisis. Oversight only works when the overseer speaks plainly. Her evasions made it look as if the Department of Justice had forgotten who it serves. Kennedy's real victory wasn't a soundbite, it was a civics lesson. He reminded viewers that procedure is protection, that probable cause, judicial sign-off, and transparency aren't paperwork formalities, but the scaffolding of fairness. When those beams crack, the whole structure tilts. His performance also underscored a deeper problem. In Washington, silence is too often a defense strategy. Bondi's professionalism kept the exchange civil, but every "I can't discuss that" felt like a door closing on public accountability. In politics, you rarely lose by staying calm, unless calm sounds like concealment. The committee left the room without clear answers, but the damage was done. Millions had just watched a senator lay out, step by step, how oversight is supposed to work, and how easily it collapses when transparency meets resistance. Kennedy's questioning didn't just bruise Bondi's reputation, it spotlighted the fragility of due process itself. Because when the Justice Department treats oversight as an inconvenience, it invites a larger question. If those with the most power can't be compelled to answer, what chance do ordinary citizens have? That's why this moment went viral. It wasn't about party lines or personalities. It was about seeing in real time the law push back against the people sworn to uphold it, and watching one senator refuse to blink. Kennedy didn't just win an argument, he reminded the country that the rule of law only works if everyone, from the lowest clerk to the Attorney General herself, stands under it, not above it.